This is elements of a successful 1094.5 writ petition. We are going to only be talking about the petition today for the most part, but we will also talk to some degree about evidentiary standards and some other issues that you might encounter when you are litigating against CCWRO, or not CCWRO, that's funny, CDSS in social services cases. So this is a specific area of law. There will be some things that do not apply widely to 1094.5s in other areas. I just want to put that out there right at the start, just in case, just to make sure there are no, there's no confusion. I will be looking at the chat throughout. If you have questions, go ahead and put it in, and I will find a good place to stop and answer those questions if I can. If I cannot answer your question, we will get back to you on that. So, David, well, I'm going to get started. Can you just monitor the waiting room and make sure that we're letting anybody else in? I don't see that everyone who signed up is in yet, but I don't want to wait too long. So.
And the Google Sheet seems to be a little hanky. So if everyone could just put their name and bar number, and I can collate that. In the
Yeah, it should be available to edit for everyone with the link. So if it's not, that's my bad. Okay, so I'm going to get started. Please, everyone who wants to sign up for MCLE credit, put your name and bar number and organization in the chat, and David will get you on that sign up list. Apologies for that. So this is the Coalition of California Welfare Rights Organization 2022 training series for welfare advocates. And I'm excited to talk about this kind of complex but interesting topic today. So let's talk a little bit about, in general, why welfare writ practice can be complex and sometimes challenging. It is a steep bar. And the reasons for that is that the evidence in a writ case is limited to an imperfect record. Often, it's limited to the hearing record, which means that you may not have all the evidence at your fingertips that apply in the case. In addition, there's strong judicial deference toward the administrative law judge, especially as the finder of fact. And of course, systemic prejudice can come into play when litigating on behalf of welfare recipients. At their heart, and this is what I enjoy writ practice and think it's very important, writs are about fairness. It's an equity, it's an action in equity, and the true heart of a writ is the fundamental principles of due process and access to justice. So it's important to keep that in mind as you work on a writ, because sometimes the technical aspects of administrative law practice can feel overwhelming, but for me, it helps to keep that focus on those equity concerns, and make that part of the story that you are telling to the judge, rather than too much focus on the nitty-gritty of the administrative process. You gotta go into that, but the focus is really on those fundamental principles. So the objectives for this training, at the end of this training, you will be better equipped to prepare and draft a complete 1094.5 petition for filing. You should be able to include all elements required for a successful administrative appeal in the public benefits arena, and telling your client's story in terms of fairness and access to justice, which is really crucial in this practice. This is a short outline of what we'll address today. I'm going to start with kind of the fundamentals. Then we're going to talk about the preparing for litigation, evidence, and the administrative record, the actual kind of nuts and bolts of the petition, and then some special considerations that really come up in these types of welfare cases. So let's get started on the fundamentals. I had a poll for you folks, but I'm not sure if I'm able to do that. I am having some technical issues. Okay, actually, let's do this right now. This is just so I can get an idea of what folks' experience is in this, and that will help me kind of target my discussion towards where we're at. And I'm going to leave that up for a minute. I think we still have people coming in, so I'm going to leave it up for a minute as I move forward with this. So I do see quite a few people in here are new to writ practice. So right now I'm going to start talking about the fundamentals of this practice and what exactly is an administrative writ of mandate, what kind of recovery is available in these types of cases, and the distinction between a 1094.5 action versus a 1085, which is similar, sometimes joined, but different in its recovery specifically, as well as in what kind of cases it's appropriate in. So what is a writ of mandate? Writs provide an appeal process for administrative hearing decisions, as well as for other governmental actions. 1094.5 specifically is for appeal of administrative hearing decisions. The statutes that are relevant in this are primarily California Code of Civil Procedure 1094.5 and the Welfare and Institution Code section 10962. We will look a little bit more closely at those, as well as some MPP regulations as we move forward. So this is a civil appeal. It's filed in the Superior Court, not the Court of Appeals, but it is an appeal process with the peculiarities of appeals. And it's filed against a government agency, local or state. For the most part, I'm going to focus on writs that are filed against the state agency, specifically CDSS. But I have a little bit of information about local about local agency writs as well. And the writ 1094.5 writs are heard and decided by a Superior Court judge sitting without a jury. So it's a bench trial. Okay. Looks like most people have answered that poll, so I'm going to end it, and I think it should pop up results for folks. Yeah, so it looks like we have a good mix here, but primarily people who are either new or somewhat familiar, which is great because that's kind of the target of this training. So don't be alarmed by the block of text here. I'm not going to go over this in extreme detail, but I wanted you to have the language because it can be very helpful to cite directly to these as you are, writing the petition, or, in the future, as you move forward with the case, a memorandum. So 1094.5A is the section that establishes that this is an appeal of an administrative order or decision. 1094.5B establishes the standard, which is abuse of discretion. And 1094.5C is the section which establishes where the independent judgment standard applies, which will be, we'll talk about a lot more later. So just to let you know, all of these slides were sent out yesterday. So if I move past something that has a lot of text like this, don't worry, you'll have it to refer to later. So what types of relief are available under 1094.5? And I put 1094.5F here because that is the subsection that establishes this. The Superior Court judge may reverse the hearing decision and order the agency to set it aside, essentially. Typically, the Superior Court judge will remand for a new hearing. So this is the typical relief that you will get with a 1094.5. It will not be, essentially, the relief will not be more than getting a new hearing. So that is something to consider when you're starting this out. If the underlying facts are not great for your client, it's a good idea to look at that and consider whether a new hearing will be helpful to them. Sometimes the Superior Court will order direct relief and directly order, this is county agency, but it's county or state, to take an action that is required by law. So that can be things like interest payments on illegally denied benefits, or the performance of a new assessment in the case of an IHSS case. So that is the overview, the fundamentals. Just to recap, the definition of the 1094.5 writ of mandate is a statutory process for appealing an unfavorable administrative decision that is heard by a Superior Court judge. The relief is setting aside the decision, remand for rehearing, or specific performance if required by law. And then I feel like we missed a slide here. So not sure what happened. Let me go back real fast. Okay, I skipped past it. So I do want to talk about the distinction between 1094.5 versus 1085 writ actions. So 1094.5 it provides for a right of individual relief from an administrative hearing decision. And a victory tends to not have a strong impact on overall policy. Now, 1085, which is it's related in process, but it provides a means to challenge illegal agency policy and compel specific performance. So this goes beyond correcting the outcome of an individual hearing and may include mandated changes to agency regulations and guidelines. This is the impact litigation statute, essentially. And oftentimes you can join together a 1094.5 and 1085, depending on the facts of the case and what kind of nonsense is going on at the county and state level. Sometimes the state or state agencies' regulations are illegal. And if that is the case, it's bringing in 1085 is the way to fix that. So just real fast, I put the 1085 statute here. It may be issued to compel the performance of an act which the law specially enjoins as a duty. So it's a narrower circumstance, but it is it can be very effective for forcing policy change where other tactics have not been successful. So they can be included in one lawsuit depending on litigation goals and what kind of relief you are looking for. So I'm going to move through this recap, and we have a little hypothetical here. I think I'm a little behind time, so I'm kind of trying to speed myself up. But so the hypothetical, and this is for you to answer for yourself. You don't have to put your answer in the chat unless you want to, in which case, you're welcome to. So an in-home supportive services recipient comes to your office with a notice of action from her county of residence. Based on the notice she received, she believes the county has misapplied proration rules for IHSS services, resulting in a large reduction in her hourly benefits. Upon reviewing the notice, you agree that the hours were incorrectly calculated and proration should not apply in her case. Would it be appropriate to file a writ to appeal the reduction in benefits? And I will cop to this being somewhat of a trick question. Just take a peek at the chat here. See people are putting in their info. And for people who have joined, we are asking that you put your name and state bar number in the chat, or you can, if you don't feel comfortable with that, you can send it directly to David, and he will add it to the sign up sheet, because we did have a slight glitch with the sign up sheet. So, okay, so since you've had a little bit of time to look at this, so the answer to this is strictly A. A 1094.5 writ cannot be filed. Yep, I see. Yep, that it needs to go to the hearing first before you can file anything at the Superior Court level. Now, if this hypothetical did say that it did go to hearing and was denied, you would then consider filing a 1094.5, probably not a 1085 in this case, because it is a specific to this person error in calculation. So let's talk about preparing for litigation. I'm going to start moving a little faster. Things to consider before you file: setting client expectations, strategic considerations, timing, and statute of limitations. And we're going to go over each of this in the slides that come next. So managing client expectations is really important in these kind of cases. You're generally working with somebody who is not very experienced with the legal system, maybe either intimidated by the prospect, or conversely thinks that a litigation path can solve these problems quickly. So it's really important to be clear with your clients from the outset about what litigation can and can't achieve for them, and to have them understand that the writ process is going to be limited to what was raised at their hearing. So essentially, and then in addition, if the 1084.5 action does resolve favorably at the Superior Court, you're going to end up going back to hearing. So it's good to let them know what the process is, so they're not surprised later, and so that they know essentially what they're getting into. Litigation is lengthy. It takes a lot of energy. Sometimes it can be intimidating, and it can take a long time before you get that resolution. With all that said, if rehearing is denied by the ALJ, the writ of mandate is the sole legal recourse for fighting an adverse decision. Some strategic considerations to bear in mind when you are advising a client on their potential options. Litigation should fit the client's needs, and not all clients are going to benefit from a writ or rehearing. Setting good precedent. If a case is lost at the Superior Court level, there is some chance that it can be published and become a precedent that could hurt future cases. This is more likely in 1085 cases, but still something to consider. And then the limitations of the record is a big one. If you have gone to hearing, or if your client has gone to hearing without assistance, sometimes the hearing record, which is going to be your body of evidence for this case, can be flawed. It can be missing important evidence. So sometimes it's better to try and ask for a rehearing if that is the case. A 1094.5 case will stand or fall on the record of the administrative hearing. So brief statute of limitations and prerequisites. If you are suing CDSS, the writ petition must be filed within a year after receiving notice of the decision. If you're suing a county agency, it's 90 days. So keep that in mind. Administrative remedies must be exhausted. The hearing decision must be final, and no new issues may be raised that were not raised at hearing. This is huge, especially if your client did the hearing on their own. Sometimes there will be an issue that you spot, but if it wasn't raised in some way in the hearing itself, you will not be able to litigate that, most likely in the writ stage. Denial of a request for rehearing or a request for rehearing at all is not required, but it can help bolster the procedural record and establish administrative exhaustion of remedies, as can a formal demand letter to the agency prior to filing. So just to recap, managing client expectations is crucial in these kind of cases. Thank you, Lauren. That's a great point. There are exceptions to the exhaustion requirement, so make sure to look at those. So strategy matters. Make sure that litigation aligns with your client's goals, and know the prerequisites so that you don't lose your client the opportunity to sue. Quick self quiz here. Again, this is for you to answer unless you want to put your answer in the chat. What is not a true statement about the requirements that must be met prior to filing a 1094.5 writ petition against CDSS? So this is specific. So the options here are: the decision must be issued and adopted by the agency. All issues in the petition must have been raised at the hearing. A rehearing must be requested, and the petition must be filed timely within 1 year. So the answer here is actually C, a rehearing must be requested. This is not a prerequisite, although it can be a good idea depending on circumstances. Everything else here is true. And so let's talk about evidence and the administrative record. This is a really important topic if you're doing this kind of litigation, because again, you are limited to the record, and the record is kind of the be all and end all of this kind of lawsuit. So we're going to talk about limitations, requesting the record, request for judicial notice, and how to look at the decision, which may well be the only thing you have before you file one of these cases. So I have said it before already, and I will say it again, you are limited to the evidence contained in the administrative record. Typically, no new evidence may be introduced via a writ petition because it is an appeal, except under narrow exceptions, but requests for judicial notice are permitted. I have put the statute here, but I'm not going to read it. So the ALJ is granted broad discretion on the admission and exclusion of evidence and is not bound by the rules of procedure or evidence applicable in judicial hearings. Administrative hearings are not bound by the rules of evidence. The ALJ is essentially the one who makes the call on that. So about the record, if the record, you will need to request the record, typically after filing the petition. There is a Welfare and Institutions Code statute that states that no filing fee should be required for the filing of a petition under this section, but not all. They may not recognize that that extends to the cost of preparing the record, so it's a good idea to have your fee waiver include that and submit it. If the record is lacking, once you get it, you may need to request a rehearing to present additional evidence, although that may be time limited. You can also move to augment the record without remand, but only when the independent judgment standard applies. So we're going to talk about this more, so don't panic if it seems complex. The independent judgment standard applies in cases involving fundamental rights, which should include most benefit cases. But there is precedent. Fukuda versus City of Angels establishes a strong presumption that the administrative findings of fact are correct. So to meet this here, you would likely need to defeat that presumption and prove that the findings are contrary to the weight of the evidence. So talking about requests for judicial notice, you can request judicial notice for certain documents, and this can really help given how technical and specific some of the regulations are that you may be citing to in your case. So for instance, all county letters or all county information notices can be, you can request that the Superior Court judicially notice those things and add them into the record. This can be requested by separate motion at the time the petition is filed or at a later point in the litigation. So you probably want to explain why you want that noticed and include a copy of the matter to be noticed, or explain why it is not practicable to do so. Court may defer the ruling on this until it decides the merit of the appeal. So sorry, I was looking at chat. In reviewing the record, this can be quite the task. Oftentimes there is a large record, but keep in mind that the full administrative record is likely not going to be available when you draft the petition. The hearing decision, the county statement of position, the claimant's SOP or statement of position, and notice of action may provide some of the documents to you. So check with your claimant client and see if they have those documents. You will have access to the ALJ's decision, and that tends to be a good place to start to identify what facts were disputed and determined by the decision, and whether the decision addresses all issues raised by the claimant. Failure to address all issues raised at a hearing in the decision can be the sole basis of a writ for remand. So if you notice that the decision did not address an issue that your client says that they raised, that is potentially a big deal and something that will win you this writ, or win you a new hearing at least. Implicit in section 1094.5 is a requirement that the agency must set forth findings to bridge the analytic gap between the raw evidence and ultimate decision or order. So this is about the sufficiency of a decision and can be very useful if you feel that the decision was light on explanations. Oftentimes the judges will just put the facts down, and then sometimes they'll just state their conclusions or what they decided without giving a full explanation. So quick recap, the administrative record is crucial. You will need to request the record. You may not have it on hand, or you almost certainly will not have it on hand when you file. And it is crucial to review the administrative decision to get an idea of what your points of argument are going to be. Just want to stop and say, Gail had a good point that a demand letter can resolve a matter prior to going to the writ process, and it is always a good idea to attempt that prior to going through this kind of more lengthy process. So self-quiz, what is not a true statement about evidentiary standards in administrative writ or mandate cases? The evidence is limited to that contained in the administrative record. B, parties can move to exclude hearsay evidence. Under the California Evidence Code, C, parties may request judicial notice of regulations, statutes, or policy documents. And D, the petitioner may request to augment the record or request a rehearing to introduce new evidence in cases involving fundamental rights. So the correct answer here is B. You cannot exclude hearsay evidence in a writ case because of the fact that the judge is the one who makes the call on that. The administrative law judge has discretion on what evidence is brought in. So those that code will not be as useful in these types of cases. Okay, so this is really the meat of this, and it's going to get a little technical and a little detailed. So bear with me, and if you have any questions or if you feel that I'm going too fast, please put your question in the chat, and I will either stop and answer it or answer it at the end. We're hopefully have some time at the end to address questions. I believe this was scheduled for an hour and a half, although I'm not sure. I will try to give time for questions if people want to do that. So we're going to talk about the petition, what makes it up, how to draft an effective one, the legal theories, and the standard of review in these cases. Wall of text again, I do apologize. So these are the parts of a 1094.5 petition or a writ petition. The introduction is optional, but I always include an introduction because it kind of, it's the old essay writing strategy of tell them what you're going to tell them before you tell them, and then tell them again. So the introduction is a good time to start telling that story that I mentioned of, you know, who your clients are as people, as humans. So then you want to have a section of parties, and I will add too here, you should have received not just the slides, but a model petition that contains kind of an example, a framework of all these. So hopefully you did receive that, can follow along. I'm going to go over this rather briefly, but there is more in that model petition that is helpful. So you want to lay out the parties: client, petitioner, agency, respondent. The agency director is typically sued in their official capacity. And then it's good to lay out a section of the statutory and regulatory framework that you're working with. And this is a good time to say the judge is not going to be incredibly familiar with the welfare code or you know, the ins and outs of the administrative process for CDSS hearings specifically. Plus there's ACLs, ACINs, there's a lot of kind of agency regulation and guidance that can be used, but in cases like this as authority, but is not necessarily something that the judge is going to be incredibly familiar with. So you want to give them a primer here without getting too much in the weeds, which can be challenging. Because there's always weeds in these kind of cases. Lay out the factual allegations. And this is where you want to really humanize your client and humanize these issues for the judge, because, well, these kind of cases can seem very technical on their face, especially when it comes to kind of the regulations and all of the different little, you know, ins and outs of things. It's really about this person and their needs that were not met in this process. So the factual allegations, obviously you want to keep it to the facts, but it's a good time to focus the judge in on what that client may be facing in their life and why it's important for them to get justice in this case. The procedural history. This is kind of a log, a history of the hearings, decisions, rehearing requests, etc. So you can cite to copies of written rulings. Daphne has a great point. It's really important to research the parties and find out who might be included. For instance, IHSS cases, DHCS is kind of a joint agency in those types of cases and should be included as a party often. I think usually we do include them as a party. Causes of action, that's kind of the meat of the petition. 1094.5 is the statute that provides the cause of action. If more than one county is involved, name them in separate causes of action, which will essentially be more or less the same wording, unless they were vastly different things happening. Sometimes somebody moves from one county to another, and that's when the trouble starts in these kind of cases. So sometimes that is important. The prayer for relief may include a stay of enforcement in the decision, a writ to set aside the decision, costs, and prejudgment interest. This is one that always trips me up. The prayer should be numbered separately from the rest of the petition, 1, 2, 3, 4. The petition format is numbered paragraphs on pleading paper. But yeah, the prayer is numbered separately. And then the petition must be verified with the client's signature and a brief declaration, typically signed by the client. But if your client is out of county, rules of court provide for signature by the attorney. So let's talk a little bit more about administrative storytelling. This is probably the most challenging aspect of writing these petitions and litigating these cases, because the administrative process is, again, complex, particular, specialized, and the challenge is to make this process and the client's experience with it both comprehensible and interesting. And best stories are always about people first. So really keeping that focus on the client, their rights, and the impact of the agency's actions on their lives and lived experience should be the central focus of the substantive facts section. Really, you're trying to appeal to the judge's kind of internal sense of justice and fairness. The dry nature of administrative procedure can sometimes really overshadow the real world harm. And so keeping the focus on those fundamental rights can remind the judge that we're not just kind of doing a technical thing here, we're talking about equity. In fact, a 1094.5 writ of mandate is a proceeding in equity by law. All right, so this is a big and important slide. The legal theories that you will likely be addressing in this kind of litigation. As I mentioned before, the primary thing that you're trying to show is that the judge abused their discretion, either by making an error of law or an error of fact. Sometimes the agency has applied an incorrect substantive standard, or applied an invalid regulation. A good thing to know is that questions of law will be reviewed de novo at the Superior Court level, which means that the reviewing court has no duty of deference. Deference can be a big problem in these types of cases. Typically, there is strong deference to the agency interpretation of the law, but the reviewing court has no duty of deference, and it's sometimes you need to remind them of that, because administrative deference is something that kind of gets a lot of attention in these types of cases. Denial of fair hearing, procedural due process violations, lack of notice or inadequate notice, and then substantive due process violations, such as decisions that appear arbitrary and capricious, lack of objective, written, ascertainable standards by which the decisions are made, or irrebuttable presumptions, are all substantive due process violations and things to look out for when you are reviewing those decisions. Decisions not supported by findings and findings not supported by evidence. Now, these are more factual And unlike questions of law, the questions of fact is subject to judicial deference. However, as I mentioned before, findings in a decision must bridge the analytic gap between the evidence and the decision. They have to explain why those facts have led them to come to this conclusion and deny benefits for the client. And if they are not doing that, then that is actionable. Burden of proof is an important thing to know here, and it does jump around a bit. So adhering the initial burden of proof rests with the agency, the county or the state agency, to justify a loss or reduction of benefits. I've seen administrative law judges get this wrong. So it is up to the agency to prove to justify the decision that they may deny or reducing benefits. Then if they do meet that burden of proof at the hearing, the burden shifts to the claimant. If the ALJ has placed the initial burden on the claimant in their decision, that is an error of law. That is something that is actionable and should lead to a remand and rehearing. Now, in the writ process itself, because the claimant is the petitioner in this case, the burden of proof is on them to show that the agency abused its discretion or made an error of fact or law. There is the standard of review is somewhat specific. Section 1094.5C distinguishes between cases in which the court exercises independent judgment and other cases. This is related to independent judgment on the facts. Independent judgment should apply in cases involving fundamental rights, which should be all public benefit cases. However, as I mentioned in a previous slide, there is precedent that kind of mitigates that standard, but it's good to know that that is kind of the basic standard because it can be employed as a good argument in these types of cases. So in an independent judgment standard, abuse of discretion is established if the reviewing court determines that the findings are not supported by the weight of the evidence. And so if you can get the court to exercise this independent judgment, the more you can get them to do that, the more likely you are to be successful in these types of cases. So sometimes it helps to remind them that they do have the right of independent review and they do not have to defer to the administrative law judge who has made the adverse decision. Okay, so I think I sped a little through that. Again, please let me know if you have questions. The structure of the petition, introduction, parties, substantive facts, procedural history, legal framework, causes of action, prayer for relief, and verification. Administrative storytelling is key, and developing this skill is something that you will probably do throughout your work in this area. Emphasize issues of equity and due process, and show the real world impact of the agency decision. Oops, sorry about that. Legal theories and standard of review. To succeed, 1094.5 suit must demonstrate that the ALJ abused their agency discretion by an error of law, a violation of due process, and or a failure to justify the decision by the findings or the findings by the evidence. The petitioner must rebut a presumption that the agency's findings of fact are correct. So quick little self-quiz here to keep everybody awake. This is true or false. Lightning round. 1, a 1094.5 petition must include a verification under penalty of perjury signed by the attorney of record. We'd love to see some answers in the chat in this one. Some of these are trick questions, and I admit to enjoying doing those. Number 2, questions of law raised in a writ petition are reviewed de novo by the Superior Court judge. Number 3, because of judicial deference to agency discretion, it is easier to argue in a 1094.5 case that an administrative decision rests on an incorrect factual determination than it is to argue that the agency applied the wrong legal standard. If the hearing decision states that the claimant did not meet their initial burden of proof in showing that the agency erroneously denied or reduced their benefits, the decision contains an error of law. So number 1 is false. It's not entirely false, but it is false as stated. It must include a verification, but it is typically signed by the client unless the situation is such that the attorney of record may sign. And that is California Rules of Court 7.103C. A person is absent from the county where his or her attorney's office is located, or for some other cause is unable to sign or verify a pleading, the attorney may sign and verify it. Number 2 is true. Questions of law raised in a writ petition are reviewed de novo. Number 3 is false. I switched these up. It's actually easier to argue that the agency got the law wrong because of that administrative discretion. And then number 4 is true. So we're getting to the end here. I am running a little bit over time due to a late start, and I apologize for that. I hope you can stay with us for a couple extra minutes so I can answer questions. So some issues to watch out for in these types of cases, welfare writ petition cases. Jurisdiction and good cause is huge. Adequate notice and due process is the basis of many of the 1094.5s that I have worked on. And then perhaps your old friend from law school, equitable estoppel, can apply in these cases, and I'm going to talk about that in a little bit of depth. So first off, jurisdiction and good cause. A writ petition can be used to appeal an administrative denial on jurisdictional grounds, and jurisdiction and hearings, as some of you or maybe all of you know, can often be based in whether or not the hearing was filed timely. Requests for hearing should be filed within 90 days of receiving notice of an adverse decision by the county. But if the notice of action is inadequate, this constitutes good cause for waiving the 90-day time limit for jurisdiction. So if you have a hearing decision that was decided on the basis of jurisdiction, but you believe the notice is inadequate, essentially the hearing decision is wrong because they denied it on the basis of jurisdiction, and that is grounds for an appeal. So this is a due process issue. If the notice is inadequate, it prevents the petitioner from understanding the basis of the agency decision. Essentially, it creates an experience of an arbitrary and capricious decision. And it can prevent the petitioner from mounting an effective appeal. So going into that more, People v. Ramirez is a great authority here. The very essence of arbitrariness is to have one's status redefined by the state without an adequate explanation for its reasons for doing so. And frankly, this happens constantly all the time when it comes to NOAA's, CDSS, NOAA's, county NOAA's. An adequate notice of action must provide enough information to clearly convey what the person must do to reestablish eligibility or correct the age determination. And that's federal law there. Again, a federal standard. It must include facts concerning the recipient's circumstances that were used to make the determination. This is a place where a lot of times you'll find that the notice falls short. It needs to cite accurately the regulations which support the action. And oftentimes, if you look at a NOAA and it's typically in small print, you will see that the regulations that are cited either are too vague or they're plain incorrect. It's always good to look at every detail of a NOAA because of that. Due process right to timely, adequate notice with reasons for termination sufficient to enable a meaningful response. So Goldberg v. Kelly is that first one. Obviously, Goldberg v. Kelly is probably the, I guess, flagship case for due process in these situations. Gresher v. Anderson is a California case that adds that sufficient to enable a meaningful response, and that can be really crucial to this argument because of the if the notice is too vague or it doesn't have case specific information, it's very difficult for the claimant to know how to respond to that. You've also got the due process clause of the California Constitution requires that notices provide sufficient information to allow the individual to understand the issues and what they need to do in response. It also provides that a person may not be denied due process and prohibits arbitrary and capricious abuse of agency discretion. So this gets a little technical, but in my experience, most notices of action that are produced through CDSS's computer system are inadequate in some way, and it's really helpful to just review those as closely as possible because they're automated in a lot of ways, and that can lead to either errors or just vagueness or fields that were left unmarked, and that can be the basis for a successful writ. Gonna go over equitable estoppel real fast. I do the next one. Sorry, looking at chat. So I was asked for an example of inadequate notice. One example is notice, which is not timely. That's inadequate. If it's late, if it does not contain if it does not contain the correct regulation or the regulation that applies, that is inadequate. There is potential. Thank you, Jessica. There's a lot of ways that the notice can be inadequate, and it can vary by program. So I'm sorry, Kevin, I don't understand the question.
The notice says you failed to provide verification. What verification?
Got it. Right. Okay. So that's basically a reason for denial. It says you failed to provide verification, but it doesn't tell them what verification they failed to provide.
Or you failed to cooperate. What do you mean? What?
Yeah. It should be specific enough so that the claimant understands what is required to fix the problem, essentially. So I do want to go into equitable estoppel, and I do apologize for running over time. But this is something that I have deployed successfully in a writ case, and it's something that I think that a lot of ALJs and Superior Court judges may not be aware of. So it's something that is good to know and deploy. ALJs have a duty to fully and fairly develop the record and consider the applicant's interests, including equity interests, regardless of whether the applicant is represented by counsel. And ALJs may apply, don't have to, but may apply equitable estoppel when there is no adequate remedy at law. Laws related to public assistance must be fairly and equitably construed. and equitable estoppel may apply to government acts when an individual has been injured because of reliance on government conduct. Now, I just noticed I should probably have defined equitable estoppel here. It is essentially it is an equity argument that says that even though the law is not on our side, fairness and justice is on the side of a decision for the petitioner. Equitable estoppel must be raised at hearing, though, but pro per claimants who are not represented can raise this issue effectively via an appeal to fairness, and that was actually the situation that I used this in. It was an unrepresented claimant. She basically said, "Judge, this isn't fair." And we successfully argued to the Superior Court judge that because she raised that issue of fairness, equitable estoppel should have been applied, did apply in this case. Because we're running low on time, I'm not going to go over every one of these elements, but I will say that the county doesn't have to actually have actual knowledge under these elements, but constructive knowledge can apply. In other words, the county should have known the real facts and just didn't know or didn't bother to do their due diligence. So these are the basic elements of equitable estoppel, with a fifth element: the injustice resulting from a failure to uphold estoppel must justify the effect on public interest or policy. So there's a balancing test here. So to recap, jurisdictional denials can be challenged if the delay in requesting a hearing was for good cause. Adequate notice, statutory and constitutional authority requires that notice of action include the facts that justify the government action and communicates what the recipient must do to reestablish their eligibility, and inadequate notice is a due process violation. And equitable estoppel does apply in administrative contexts if there is no adequate remedy at law and the petitioner has relied on government conduct to their detriment. So this is a little self-quiz, last one, I promise. What is not a true statement about evidentiary standards in administrative writ of mandate cases? A, jurisdictional time limits on fair hearings may be waived if the claimant can show good cause. B, equitable estoppel can be raised at a writ petition, even if the claimant does not explicitly raise the issue of estoppel at hearing. C, if a county worker misrepresents program rules to a recipient and the recipient relies on that misrepresentation to their detriment, the ALJ may apply equitable estoppel against the agency when there is no other remedy under the law. D, ALJs have an affirmative duty to develop the record if the claimant is unrepresented. And E, all of the above statements are true. So E is technically the answer, but D is actually partially true. ALJs have the duty to develop the record, consider the interests of the claimant, and address issues of equity, regardless of whether the claimant is represented. This is a really good standard to keep in mind because oftentimes the ALJ takes a passive role in a hearing, and that is a violation of their administrative discretion. They have an affirmative duty to address issues of equity and develop the record in full. Okay, so I've gone into darkness. So we are a little over time. I do want to give an opportunity for questions for those who have hung on. So Lauren Hansen has a good point. equitable estoppel is not available specifically in CalFresh overissuance cases. So there are some areas where you may not be able to use that. My favorite notice of all time was one that said, "You did not do what you needed to do." Amazing. That is an inadequate notice. That is a grossly inadequate and disrespectful notice. Thank you so much, you guys. This was my first training, and I appreciate all of your patience with my technical issues at the beginning and late start. I really appreciate everyone who attended and participated. If you have additional questions, or you feel that I went over something too fast, or something was raised that you want to know more about, please feel free to email me. I'll put my email in the chat, and I will do my best to answer your questions. Oh, that did not go to the correct person. Sorry about that. And I did have a request for more examples. I don't have those at my fingertips, but I would be happy to provide those. If you shoot me an email, I'd be happy to talk with you about it more. And that's all I had for you today, unless anybody has additional questions. I really appreciate your time, and I appreciate you bearing with me. And I hope that this was helpful to you in some way, or at least giving you a start on these types of petitions. And with that, I will, I'm going to leave it open for a couple more minutes. I don't want to just close it out in case somebody has something that comes to mind. I was going to discuss procedural steps, post-filing, and memorandums and motions, but that is definitely opening a whole new can of worms that I don't have time to talk about right now. It may be a topic for future trainings. If folks are interested, please let us know. And we will be sending out an evaluation form as well as your MCLE sheets later. Prior to this, we are also happy to help consult with any writs you are working on. Our staff, our litigation staff at CCWRO, we primarily do this kind of practice, and we're always happy to help out on your cases if you wish, or if you want. So please feel free to contact us about that. We are going to be sending out those eval forms. Please fill them out. Let me know if you have feedback for me. Since I am new at this, I will take your feedback to heart. And I appreciate everybody's time today.